What is conditional residence in the marriage-based green card process, and what do you do about it? Welcome to Sumner School Family Immigration Basics. My name is Emily Sumner with Sumner Immigration Law. In today's episode, we are talking about what is conditional residence. So conditional residence is granted when a couple has applied for a marriage-based green card and they have been married for less than 2 years as of the date that the foreign national receives the green card. The purpose of this conditional residence is so that USCIS has a chance to confirm later on down the road in about 2 years whether the relationship is actually a valid relationship. That does not mean that you still have to be married. There are exceptions to that process that we'll talk about in just a minute. But the conditional green card will be valid for 2 years. Within the 90-day window before that green card expires, generally speaking, assuming the couple is still married, you will have to file a joint petition using Form I-751 to remove the conditions. That's the legal term that it refers to the process of taking care of this 2-year green card and applying for a 10-year green card. It's important to know that conditional residence can apply, will apply, like I said, if you have been married for less than 2 years as of the time you received the green card, regardless of how you actually received the green card. So yes, it's marriage-based, but I mean, you have conditional residence, will have conditional residence, whether you filed for the green card here in the United States through USCIS, whether you entered on a K-1 and applied for a green card here in the US, or if you went through the consular processing and received an immigrant visa overseas and then received the green card once you're here. Any of those ways, you can still receive conditional residence if it's applicable. So when you file the I-751, like I said, generally speaking, there are exceptions, but generally speaking, a couple would need to file it within the 90-day window before the green card expires. When you file that form, you also will want to submit supporting documentation to show that you still have what's called a bona fide relationship. So still that you're still married, still living together, that everything is going well, relatively speaking. So you will submit updated documentation similar to the documentation that you submitted with your marriage-based green card. And we have a previous video in this video library of Sumner School Family Immigration Basics that talks about the documentation that you could consider submitting for a family-based or marriage-based immigration case. That is similar documentation, but you want to make sure it's updated. So USCIS generally does not deem that documentation that you previously submitted or that's from prior to applying for your green card. They want to see that since the time that you received that conditional residence, you have maintained that relationship and it's still a true relationship. Like I said, there are certain exceptions. So if a couple is divorced already, it is absolutely possible for the foreign national spouse to file the I-751 to remove the conditions. However, you will need to include the divorce decree and you still have to show that it was a bona fide relationship, at least at the time that you got married. In addition, there are exceptions for death. So if your US citizen or permanent resident spouse has died, unfortunately, you can still file on your own. And there are exceptions for situations of abuse as well. When you submit the I-751 petition with USCIS, you will receive a receipt notice from USCIS that says, as of right now, so as of July of 2025, when you receive the receipt notice, it will say that it is extending your residence, your status, your resident status here in the United States for up to 48 months. Yes, 4 years from the date that your conditional residence expires. The reason it's valid for so long, the reason it extends your residence for so long, is because it takes USCIS so long to adjudicate this particular type of petition. So right now in practice, we're seeing that generally speaking, USCIS is taking at least 2 to 2.5 years to adjudicate this type of petition. So it's not at all unusual for it to take a long time. So with that receipt notice, like I said, as of right now, this is subject to change in the future, but as of right now, with that receipt notice, you can use that receipt notice and the expired green card to work and potentially to travel. Definitely talk to a qualified immigration attorney before you travel, especially in this environment. But it does allow you to provide the legal documentation that you would need to apply to re-enter the United States. It is possible that you would have an interview for the I-751. We see that that happens in some cases, and in some cases it does not. It just depends on the specifics of the case and the particular officer, honestly, that is adjudicating your case. Once the I-751 petition is approved, the foreign national spouse will receive what's called a 10-year green card. So you will have permanent residence instead of conditional residence, and the green card will be valid for 10 years. One thing that's important to note is if the foreign national spouse is interested in applying for naturalization, that is the process of becoming a US citizen, the foreign national spouse can do that, generally speaking, as long as they have lived with, been married to, and are living in marital union with the US citizen spouse. So if your spouse is a permanent resident and that's you filed based on that, that doesn't apply. But if you are married to a US citizen and have been living with that person for at least the past 3 years, you can apply based on after a period of 3 years. That 3-year period includes the 2-year period of conditional residence, which is fantastic because in many situations, our clients have the I-751 petition pending with USCIS. Like I said, it takes a couple of years at least for that to be processed. While that is still processing, while it's still with USCIS, we file the N-400, the application for naturalization. That generally is approved much, much faster. So right now we're seeing that that can be approved in as little as 6 to 8 months. Sometimes it takes longer, sometimes less, but 6 to 8 months. And that can be approved even though, or it can be filed rather, even though the petition I-751 is still pending. What happens is when USCIS receives the N-400 application, they will pull the I-751 petition as well, and they will process both of them at the same time. So yes, they have to approve the I-751 before you become a US citizen, but it makes that process faster because they will pull the file and adjudicate both of those together. So that's something that our clients do regularly, and it's amazing, a great way to hasten the process of the I-751, and a bonus, they get to become US citizens. So keep that in mind if you are in that particular situation. I hope that you have found this information helpful. If so, I hope you'll share this video with a family member or friend, and make sure you're subscribed to our channel so that you don't miss our next video. My name is Emily Sumner with Sumner Immigration Law. We serve clients around the world and around the United States with family-based and employment-based immigration matters. Until next time.